the judiciary will need to redeem itself. And like I keep saying, apart from the judiciary, the legal profession needs also to redeem itself from the battered image that it has put itself. And when you listen to some of their lordships that have retired, you begin to know that all is not well. So it must revisit some of its decisions that seems to have put roadblocks on the wheel of justice and seem to have encouraged Nigerian politicians to engage in reckless abandon and undermine the sovereignty of the people. Decisions such as you are insisting that you must front-load a witness statement of a supine witness before the election petition is filed. It's a decision that the Supreme Court must revisit if it's not going to be accused of aiding and abetting the destruction of democracy in Nigeria. Because if that is not reviewed, it means that in 2027 or some of the other off-season election, or those exhibit, or those evidence, because we have now had a decision that says you must front-load all your witness statements on oath before you file petition within 21 days. I do not think that that is justice. So the Supreme Court must revisit it. Two, I think time has come that the judiciary itself must also think of giving justice in judgment, rather than the multiplicities of judgments that are being dished out, that when you look at critically at that justice that comes, judgment that comes out of court, a lot of them contains injustice. Because once the decision is not fair, the decision does not represent the reality on the ground, the reality that everybody knows, the reality that market men and women know, the reality that the artisans know, and you produce documents, and then we begin to employ what they call sui generis rules of construction or principles of law in a negative form. Because I think that if we want to use the concept of sui generis in electoral jurisprudence, it should be in favor of the courts admitting documents and relax some of the rules of technicalities that cause them to close eyes to otherwise documents that are available that shows infraction. But you come and hear such principles that you have a document, you must demonstrate it. How do you demonstrate what is written in English language? The official language of Nigerian courts is English language. The lingua franca of Nigerian courts is English language. And so if a document is written in English language, you see mutilation, you see cancellations, you see a person struggling to make addition. You go, you produce a result from polling units. When you put them together, the results are less than the total number of results that have been given to the supposed winner of election. And you are still telling me that in the face of Form E8As that shows otherwise, I must still go and produce somebody from polling unit by polling unit. Where do you have that time, given that you have 180 days to prove and judgment deliver an election petition? So the concept of sui generis that have been negatively interpreted by our courts to affect the rights of supposed loser of election petition must be revisited in 2024 and beyond. We must go back to the good golden olden days where the Supreme Court itself says that if there is anywhere that technicality should not rear its head, it should be in election petition. The reason being, as their lordship reason rightly in my view, that in deciding election petition matter, you are not dealing with just the right of the parties before the court, but you are also dealing with the rights of the electorate and the Nigerian people who had exercised their fundamental right to make choices of who to govern them. So we have decided to employ this concept of sui generis negatively, in my estimation, and I think that they need to revisit it so that it be employed in a positive way that enhances democracy. So the judiciary and the legal profession must note that Nigerians are watching, and like I have said, I've written, if we are not careful, we may not be able to escape the mob action of the public, who sees every one of us as part and parcel of Nigerian problem. I mean, the day never come when a judge sitting or a lawyer passing on the road will be stoned because of what we do. And so we must go back to the priesthood that is our calling. Lawyers and judges are priests. And so we must go back to the priesthood where we must be husband and wife of one husband of one woman and wife of one husband, so that, and I use that figuratively, so that we don't engage in polygamous adulteration of justice in Nigeria and then sitting there thinking that we can give equal love to all the parties. No, it cannot happen. So we must purify our hearts, must purify ourselves, we must go back to the ethics of the profession and give undilute justice to our people in 2024 and beyond. And once we start giving the right decisions, right judgments, we will discover very shortly that investments will overcome will come to Nigeria's economy, and the economy will become so booming that unemployment will be a thing of the past.